transfer of data between businesses in Europe and United States has been operating effectively until July 16, 2020. When the European Union Court of Justice ruled on the restriction of personal data transfer of EU citizen. What does the ruling entail? The ruling restricts the transfer of personal data of European citizens to jurisdictions outside the Union, therefore, invalidating the Privacy Shield Agreement (PSA). What is the PSA? In 2015, the US and European government entered into the PSA. Major US companies, particularly tech giants, use the PSA because it allows for individual contracts when sending out data outside the EU. However, these individual contracts are valid only if the US companies can guarantee the clauses embedded in the Standard Contractual Clauses (SCCs). The SCC ensures that EU citizens have sufficient rights to challenge any surveillance issues that may arise. It also ensures that proper judicial redress is in place to cater to any problem that may arise from the data that is transferred. The bloc's top court stated that the US does not guarantee these standards. Why did the bloc's top court make this ruling? The ruling came as a result of multiple complaints filed by privacy activists concerning disclosure and handling of their personal information on Facebook. In 2013, the initial claim was filed as a result of the former U.S. National Security Agency contractor Edward Snowden's revelation on how the U.S. government gets access to online data and various communications of individuals, including EU citizens, for national security reasons. What is the way forward for tech giants and other businesses in the U.S.? Since the imposition of the landmark ruling, many U.S. businesses that deal with EU citizens are overwhelmed with confusion as to the strategic ways to deal with data transfer of their EU customers. The major questions for major data-driven companies are: 1. Will data localization become the new strategy for U.S. companies? 2. Will data localization be the most effective way to minimize risk? 3. Will the EU's decision compel the US to enact stringent data protection laws against other continents? Acktinos recommendations. Notwithstanding the present uncertainty that cloud the affairs of technology companies in the US, here are a few recommendations from our regulatory consultants at Acktinos, LLC. Consult with IT compliance officers or legal analyst IT experts IT analysts to better understand the latest decision, to conduct an in-depth review, and to assess the existing customer data. The outcome of the assessment must be documented and communicated to the senior leadership and decision makers of the company without delay. Companies must develop an effective action plan to address the changed privacy and data protection law in order to minimize risk. For more information and help on how your organization can adhere strictly to the latest EU privacy and data protection laws as well as on GDPR, please consult our experienced experts at support@acktinos.com, 737-717-0506. Acktinos.com